Under their general police powers, states may regulate public service corporations, such as railroad companies, by fixing reasonable rates they may charge for their services. However, if a rate fix isn't reasonable, it may constitute an illegal taking of private property for public use without just compensation under the Takings Clause of the Fifth Amendment, applied to the states via the 14th Amendment. But what constitutes a reasonable rate that a public service corporation may charge for its services? The United States Supreme Court addressed this question in the 1898 case, Smyth v. Ames. In 1893, Nebraska's legislature passed a statute to regulate railroads that fixed maximum rates that railroad companies could charge for their services within the state. However, based on financial data from 3 years before the law's passage, some railroad companies would have suffered losses in the state under the maximum rates that Nebraska had set. Stockholders in railroad companies operating in the state, including Ames, sued Smyth, Nebraska's Attorney General, in federal circuit court to enjoin the law's enforcement. The stockholders claimed that the law was an illegal taking of their property and unconstitutional. The circuit court found for the stockholders, concluding that Nebraska's law amounted to an illegal taking and was unconstitutional because the rate fix didn't allow the railroad companies to obtain reasonable compensation. Smyth appealed to the United States Supreme Court.